So hi everyone, my name is Mariel Shutinia. I'm an attorney at Maryland Legal Aid in our Community Lawyering Initiative unit. So we go out into the community normally and meet people where you are to provide legal services. Go to the next slide. So just real quick, I'm going to go over what legal aid is and kind of how we work just for a few minutes so you know, and then I'll talk about expungements. If there's anything that you need help with that I talk about here, I will provide my contact information at the end. See if legal aid can help you with your criminal record expungement. And I'll also talk about a few other things we do, just so you know. But just for a heads up, legal aid is a private nonprofit law firm, and we provide completely free civil legal services to people that are financially eligible. So we have offices, we have 12 offices throughout the state. So we have one in Baltimore City, right across from City Hall. We have a Baltimore County office, and then everywhere else in the state. And right now, with the pandemic, we're doing most things virtually. So over the phone, email, Zoom, anything that works, just so we can reach everyone. So if you're financially eligible, our services are completely free. And that's our website right there, www.mdlab.org. Our service will be completely free, and that means filing fees are waived, also court costs, things like that, just to try to help. Go to the next slide. So the types of cases we handle, I'm going to talk about criminal record expungement today, which is something we do a lot of, especially me in community lawyering. We handle a lot of other civil legal issues. So things like consumer rights, we have an elder rights department, employment law, family law, so there'll be custody, divorce, child support, things like that, farm workers' rights, government benefits. This is one that people a lot of times don't realize you can get legal help with, but if your benefits are denied, especially right now with unemployment benefits, that's the big one, things like that, we can help. Healthcare issues, housing, so renters issues, evictions, that's going to be a big issue right now. So we help with that. Veterans benefits, criminal record expungement, the reason we're here today. We also have a special unit for children in need of assistance who need an attorney outside of their guardians, and then foreclosure assistance as well. We do a lot of other things too. These are all civil legal issues. So if there's something I didn't list, please feel free to call us anyway and see if we can help with it. And we can always direct you in the right way if it's not something we can help with. An important note is that legal aid does not handle criminal cases. So if you do have a pending criminal case and you can't get a private attorney, you can't afford one, you can contact the Maryland Public Defender's Office. They handle the criminal side of this stuff, and then we're going to do civil. Criminal record expungement, though, is technically civil. It's not a criminal case anymore. So that's why I can help with that. Next slide. And just so everyone knows, we do have an intake process. So you have to be financially eligible to use our services typically. And I want to put this out here right now in case you do call to use legal aid, because we do ask some kind of personal questions, and I want to put that up front. So we'll conduct an interview over the phone right now, or it can be done online, whatever is easiest. And it asks about your income, family size, assets, some other information. Everything is completely confidential. It does not get shared. It's just to make sure that you're eligible for our services. Then we'll ask about your legal problem, and again, that would be confidential as well, just like any other attorney you'd speak with. Sometimes we have something called a conflict of interest. This is usually when there's been a dispute and we've represented the other party before. So a really common example would be if two tenants are having an issue with each other, we can't represent both of them. Our law firm can only represent one. Or in a divorce, we'd only be able to represent one of the parties. So even if that was years ago, that other person still, is technically a client of legal aid, so we wouldn't be able to help. But in that case, it's nothing personal. It happens a lot, unfortunately. We're such a big law firm. And it can be really devastating or frustrating to get that information. That being said, if that happened, again, it's absolutely nothing personal. We would love to provide services, but we can give you the information for another legal service provider that does the same things for free as well. So obviously, just feel free to call and we can at least get you that information. Next slide. All right, so the reason we're here, criminal record expungement. So I'm going to talk about, how it works and what it is. So the first one is, what is expungement? Expungement is the removal of records from public inspection. So basically anytime you walk into court, if your name was on those court documents, it's going to pop up on something called Maryland Judiciary Case Search. So if you get an expungement done, the records will be removed from your MVA files, those traffic related, the police files will be destroyed, those court files, and then that public record search would be erased as well. Unfortunately, no process is going to expunge records from absolutely everything. So, we're Maryland legal aid and we're only dealing with Maryland records. So the Maryland laws around expungements mean that the Maryland courts and the Maryland agencies have to expunge, destroy these records. It doesn't necessarily mean that other places will. So something like an FBI background check might still contain that case information, but there'd likely be a notation that it has been expunged. But a lot of times that's not really affecting a lot of people. If you're just getting a fingerprint background check for a job in Maryland and you went to get that done, if it's expunged, it's not going to pop up on that anymore. Next slide. So why expunge? We know what it is, but so any arrest is public record, even if you weren't convicted. So I hear this a lot of times. I'm talking to someone and they say, oh, I don't have a record. And I look it up and there's a few things on there. It was dismissed or they were found not guilty and it was 20, 30 years ago, but it's still up there and it's still public record unless you request the court expunge it. So this can impact a lot of things. If you're applying for jobs and those things are popping up, housing applications, child custody, loans, applying to school, whatever it is, it's public record. And also, I'm of the mindset that if it can come off, why not? I had a speeding ticket a few years ago and it has your personal information, it has your address, all those things. That was removed eventually and it wasn't affecting me really, but if it doesn't need to be up there and we can take it off, I think it's a good idea. Next slide. So just real quick, and I'm going to talk a lot about what's eligible for expungement and what isn't and how the process works. But kind of up front, when we're talking about expungements, at least for what I can help with at legal aid, it has to be criminal charges obtained in Maryland. For Maryland legal aid, we can only work on Maryland cases. I'm only licensed to practice law in Maryland, but also each state has completely different expungement laws. Maryland's are unique to Maryland. So we can only help with those Maryland charges and no federal charges. There's no comprehensive federal expungement law, unfortunately. And again, I can only help with those state charges. If you have charges in another state, say Pennsylvania, we hear a lot, Virginia, always feel free to call over to, or just you can Google it as well. But the legal service providers there, the legal aids there may be able to help you with that, but you will have to speak to the attorneys in that state. When we talk about expungement also, it's usually criminal records, but some traffic counts as well. So we talk about it if there's a penalty of incarceration potentially. So, running a stop sign, there's no possibility you can go to jail for running a stop sign. It's a citation, it's a ticket, you have to pay it, that's it. So if that can't be expunged, that's administrative, and I'll talk about that in a second. But any traffic that has a possibility of incarceration, so driving on a suspended license, if you're found guilty of that, technically you could serve jail time. I'm not saying you will, not saying that that was the penalty imposed, but it's technically possible. And so that falls into criminal traffic. So that is something that may be eligible for expungement. DUIs and DWIs have some special rules around them, but I'll address that a little bit later. And then one of the really big things in Maryland is that you can't have a pending criminal case if you want to file for expungement for any cases. So you have an open case right now, and you want to have something expunged from 10 years ago, you have to wait until that open case is closed out, and then you can file for expungement on things from before. It's just a little quirk in the law. It can be very frustrating, but there's not really much we can do about it, unfortunately. We just have to wait. But being on probation or parole does not count as a pending case. So if you're serving, probation for something, that's totally fine. We could still file for expungement on other charges from before. So we could always just look at it and check. Next slide. So like I talked about just very quickly, there's incarcerable traffic cases, the criminal traffic that maybe we can help with expungement. But for other traffic offenses like using your cell phone while you're driving, or speeding tickets, or things like that. Like I said, you can't go to jail for those. It's just not part of the law. So in general, the majority of those minor traffic cases will be automatically purged from your case search record and your driving record after some period of time. You don't have to do anything, it's automatic. Usually about 3 years, but it depends. So if you want, there's a website down here at the bottom, but it's probably easier just to Google MVA expungement or Maryland traffic expungement, and that will pop up and that'll explain it. There's just these waiting periods, but usually you don't have to do anything. Those minor traffic cases will just disappear. Next slide. All right. So normally when we're identifying criminal charges in Maryland that may or may not be eligible for expungement, we use something called Maryland Judiciary Case Search. That's when I refer to case search, that's what I'm talking about. And that's the website right there, casesearch.courts.state.maryland.us. This is public record. It's basically a Google search. Anyone can look at it. Anytime your name's been on a court document, you type that name into case search and it'll pop up. You can look me up. You can see all the cases I've been an attorney on. Hopefully not too many because they've been expunged, so you won't be able to see them anymore. But that can work for anyone. So many times that's what we'll use at legal aid, or that's what other people will use, or if you're doing it on your own. It's free, it's right there, it's easy, and you can look at it immediately. There are a few issues with case search though. It's not comprehensive and it's not always accurate. So one, if you have cases that are older than the early 90s and the 80s or 70s or even before then, those haven't been digitized necessarily. So they might not be on this online database. And also it's not always accurate, unfortunately. They could have mistyped your name, or a birth date's wrong, or there's just a person typing this information in. And so just with human error, there could be something. So if your name was spelled incorrectly, or if you have a really common name and there could be many other people that have maybe a similar birth date or something like that, sometimes case search isn't good enough. If you look at it and everything on there is accurate and it looks right, then that's normally what we would go off of, because you don't need to do anything else. We can just access it. But if you want to get your full record that will come up with fingerprints, you have to go to the Criminal Justice Information System, CJIS. You get fingerprinted, and that will give you the complete record of anything on your record that is related to your fingerprints. This does have a cost. I think it's about $38. And in those cases, we can't get that waived, unfortunately. Like I said, at legal aid, normally we can get filing fees, court costs, other things like that waived, but this is one that you do have to pay for. But if you need it, I think it's worth it, but it is just good to know. Next slide. All right, so normally when we're talking about expungement, it's based on the disposition of the case. So if it's a conviction, it matters what the charge was. But for any other disposition, it just really is, what happened in that case. It doesn't matter the charge. So what we're going to talk about now is the different dispositions, the non-guilty dispositions that are eligible for expungement. So a null pros, when the state's attorney declined to prosecute the case. We see these all the time. For those, there's a 3-year waiting period. So 3 years from the date it was entered, the disposition date is what I'll keep calling it. You have to wait 3 years from that date to file a null pros off your record. So that's not a hard waiting period at all, though. There is a general waiver and release you can sign, and then you can file right away. I have heard of people getting a null pros in court, literally walking downstairs to the clerk and handing them the expungement paperwork right then. As long as you sign this general waiver and release, you can file immediately. So what it says is you're not going to bring a lawsuit against, or any claim against any state, the state's attorney, the police, anyone like that, whoever made the complaint for the charge, you're not going to bring any suit against them. I used to think this was a little concerning anytime you have to sign away that right. But what it is in Maryland is a 3-year statute of limitations to bring one of these cases. So they don't want to expunge the charge, have someone bring a lawsuit, and then they can't view the record to defend themselves because it's been expunged. So normally, as long as you're okay with signing that waiver and release, there's no waiting period, and you can file for a null pros or not guilty or dismissal. So those are the other 3. Null pros, not guilty, or dismissal can be filed right away if you sign the waiver and release, or wait 3 years. For a stet, which is the indefinite postponement of a case. So it's a lot like a null pros, but technically the state's attorney can reopen that case within a year, and then for no reason, and if for any reason they want, and then for 2 more years after that if they have a good reason. So for that, there is a hard 3-year waiting period. The statute wants to allow the state's attorney's office the ability to reopen that case. So there's a hard 3-year waiting period for stats. You can file something called a motion for good cause when you have a really good reason for why that 3 years is too long. And if you think you have something like that, definitely feel free to give us a call, and it's something we could talk about. Another really common disposition you see is a probation before judgment. So this is usually someone pleads guilty, but instead of it being a guilty, they're given probation. And if they serve that probation successfully, it will stay a probation before judgment and not turn into a guilty. We see these all the time. So this has a hard 3-year waiting period or the end of the probation, whichever is longer. This sounds a little confusing. I've even had judges get confused about this one. But what it is normally a probation before judgment that is 3 years or less. So your probation was, 2 years. In that case, you just wait that 3 years, and then you can file for expungement on it. If you had a probation that was 5 years, you have to wait for that to be over. And once you've hit that mark, then you can file for expungement. You can also do motions for good cause for these. They're a little harder to get too, but it's worth talking about. The important thing to remember before probation before judgment, though, is that in that 3-year waiting period, you cannot have a conviction for another crime. So if you had other charges, but they were null pros or another PBJ or something like that, that's okay. But if you have a guilty in that 3-year waiting period, your probation before judgment can't come off your record unless that guilty is eligible for expungement too, which I'll talk about. So, sometimes these are really easy and you can do them on your own. You don't need a lawyer to file them, but I really do recommend reaching out to us if you have these issues, because our services are free if you're eligible. And sometimes it gets a little tricky with these timelines and looking at it. And then the other big one is a release without charge. So basically this is an arrest and then you were released. The state's attorney didn't file any charges, nothing happened. If this happened to you after October 1st, 2007, this will automatically be expunged 60 days after your release. You don't need to do anything. If this happened before October 1st, 2007, you do have to request the agency, the police department, get rid of that record for you. Technically, it needs to be within 8 years of the incident date. That doesn't make any sense because obviously 2007 was much more than 8 years ago. I've never heard that being an issue. If you have that problem, just let me know. We don't really handle those, but we can get you the paperwork for it. I've never heard of anyone having it denied. Basically, the police department just needs to know what record to go find. They have to go search through the records to find it. So that's why you need to file the paperwork with them. Next slide. So what else can be expunged? So like I said, with guilties, so if you were found guilty of a charge, it depends on what the crime was. So like I said, if you get a null pros for anything, that can come off your record. It doesn't matter what the charge was. But when we get into the eligibility of guilties, it matters what the crime was. So for things called nuisance crimes, these are very minor crimes, and they're going to be things like urinating in public, riding transit without paying the fare, really any MTA citation, eating on the train, panhandling, sleeping in a park, vagrancy, loitering, drinking alcohol in public, things like that. If you're found guilty of one of these, there's a 3-year waiting period to have that expunged from your record. There's no subsequent conviction rule like with the PBJ where you can't have a guilty in that period. With a nuisance crime, if it's one of these, you have to wait the 3 years. Doesn't really matter what happens in that 3-year period, and then you can file for expungement. Another really common guilty that we see is guilty of a crime that's no longer a crime. So possession of marijuana less than 10 grams is no longer criminal in Maryland. You receive a civil citation if this happens now. Because of that, doesn't make a lot of sense that those guilties would have to stay on your record because it's no longer criminal. So if you have a guilty for possession of marijuana less than 10 grams, that can be filed right away as well. And then also if you received an unconditional governor's pardon, a lot of people don't know this, but if you receive the pardon, you still have to request that it be expunged from your record, that case. So these are uncommon. We don't see a lot of them. We don't help with pardons really. I could get you the paperwork if you need it. They're hard to get, but I have seen them before, and you do need to file for expungement even once you've received the pardon. Next slide. So what cannot be expunged? This is general, and I'm going to talk about all the exceptions, but generally, unspecified felony convictions and unspecified misdemeanor convictions cannot come off your record. So those nuisance crimes, or that, marijuana less than 10 grams, those can come off. And then any guilties for any of these other crimes, they can't come off your record unless the statute explicitly says it. It has to be written in there that this charge can come off. So I'm going to talk about what those are, but in the general rule is the guilty is going to stay on. So something like driving on a suspended license, that's not included in the statute for a guilty that might be able to come off. So something like that is going to be stuck on your record. And the problem with that too is that could be a subsequent conviction. So if you have that PBJ that's almost ready to come off your record, but you get a guilty on one of these unspecified misdemeanors, which could be something as minor as driving on a suspended license, that PBJ might be stuck. So it's important to know that. Another really important one that can be very frustrating is something called the unit rule. So unit is 2 or more charges arising from the same incident. And those minor traffic things, we just ignore them. So if you got a speeding ticket at the same time you're arrested for a drug charge, it doesn't really matter what happened in that speeding ticket. It's minor. Like I said, those are, they're not criminal. We don't have to deal with them. But something really common in a unit would be, possession of some drug and the paraphernalia to use the drug. So if you got a no pros on one, but you got a guilty on the other, and that guilty can't come off, neither can that no pros. So if all the charges in a unit from one incident aren't eligible for expungement, none of them are. This we're hoping might change soon, but we don't know. It's up to the legislature. So right now, that's the way it is, unfortunately. And then another really important distinction is, like I said, with those probation before judgments, those PBJs, after 3 years, typically you can file for expungement. A PBJ for a DUI or a DWI is never eligible. It's the only PBJ that isn't ever eligible based on the charge. And like I said, there's that no subsequent conviction within 3 years of the PBJ, except for minor traffic violations. You could plead guilty to speeding or running a red light or something like that, and that's not going to affect your PBJ's eligibility. So these convictions, like I said, normally your convictions are going to be stuck on there if they're not a nuisance crime or a minor marijuana charge or something like that. But there are 100 misdemeanors and 3 felony charges that are eligible for expungement. So in 2017, the Justice Reinvestment Act was passed. And what this did is it listed out over 100 misdemeanors, and then a year later in 2018 added 3 felonies that are eligible for expungement. So if you were convicted of, there's 100 of them, and I'm not going to list all of them for you. You can look it up online, or again, always feel free to just reach out to us, because again, our services are free. We can do it over the phone, and we know these pretty well. But the really common ones you're going to see are drug possession, prostitution, theft, disorderly conduct. These misdemeanors have a 10-year waiting period. You have to wait 10 years from the end of the sentence date. So if you serve time or you serve probation or something like that, that's your start date. And then you wait 10 years. And in the 10 years, you can't have a subsequent conviction. So it's kind of like the PBJs. If your subsequent conviction becomes eligible for expungement, then you can, but it's a waiting game. And the 3 felonies, they're not listed out here, but just so you know, are going to be felony theft. So theft over a certain amount. Burglary, 1, 2, and 3. They forgot to add 4, which is the most minor of them. But normally we can still try to file those because it's just an accident. I think they left that off. And then possession of some drug with intent to distribute. So if you had a guilty on possession with intent to distribute, usually some larger amount, that will be eligible after 15 years. So second degree assault and those 3 felonies I just described have a 15-year waiting period. And then one that's not on here, but it's really important to know is if you have possession of marijuana more than 10 grams, but not a possession with intent level. So really any amount in there, those you have to wait 4 years from the date of the disposition date. There's no subsequent conviction rule on those either. So for possession of marijuana charges, it's 4 years, but possession of any other drug, if it's a conviction, it's going to be that 10 years with that subsequent conviction rule hanging in there too. Next slide. So like these waiting periods, I'm going to say them one more time because they can be very frustrating. In general, those 100 misdemeanors or so has a 10-year waiting period from the end of the sentence date before you can file for expungement. The exception is second-degree assault, although technically a misdemeanor has a 15-year waiting period. And then those felonies I just talked about have that 15-year waiting period as well. So it cannot be expunged. Again, that unit rule still applies. So if you get convicted of an ineligible felony or one of those ineligible misdemeanors from the same incident, if that can't come off, the other ones can't either. So if you had a possession of marijuana charge that you were found guilty of, and then first-degree assault, which isn't ever eligible, even though it seems like that possession charge should be eligible eventually, since it's from the same incident, the same unit, it's not expungible, unfortunately. And like I said, again, that subsequent conviction rule applies. If you can get convicted of a new crime during the waiting period, the original conviction you wanted to have off is not eligible unless the new conviction becomes eligible. So sometimes you have to wait, for your last conviction to get the 10-year mark or 15, whatever it is, and then you can file a lot of things off. And again, there's no pending criminal cases, like I said, but probation, parole, or mandatory supervision does not count. They're not pending cases, you have a disposition entered. But for these convictions, you have to wait for your probation or your supervision or your incarceration, whatever the penalty was, that has to end before the time starts. And then again, like DUIs and DWIs, they are not eligible for expungement ever under the law right now, PBJ or conviction. So how do expungements work? So like I said, those are the kind of the baseline rules for what can and cannot be expunged, which is helpful to know. And if you really need any assistance with this, let us know. But what happens after you file? So if you were working with legal aid or really anyone else for an expungement, you file a petition with the court. It's a form document basically, and you put the information in about when you were arrested, what the charge was, what the date of the disposition was, so they can do that counting. Check off the box for what the charge was, and then you sign it and file it with the court. Once you file it, the court does their thing with it. Sometimes it's quick, but with the pandemic, the courts are closing. They're in different phases of being open, so it's a little harder to determine the timelines. But generally, once the court receives it, they let the state's attorney know, and they have 30 days to object to the petition. They could object for a lot of reasons. They're not too common, but one would be there is a subsequent conviction, and for some reason we didn't see it or didn't know about it. That could be a reason. And if there's a victim, so usually if it was a guilty and there was a victim involved, they are informed as well and given the right to object. If no one objects within that 30 days, the court must enter an order for expungement. This doesn't always happen depending on the court, but generally that is the rule. So usually I always say if we file expungements, you don't want to hear from me for a few months, because if you hear from me in those waiting periods, it means something happened. Silence is good when it comes to expungements, because if you don't get an objection, typically the expungement will go through. But if someone does object, so the state's attorney, the victim, and sometimes the police object as well, the court is supposed to hold a hearing. So at these hearings, the state will present their argument for why it's not eligible. If you were using legal aid to file these petitions, we would represent you at a hearing if that happened. I want everyone to know, though, in most cases, there's no hearing, there's no objection, it just goes through, and you get an order signed by the judge in the mail. And then after that order, if that order comes from just the judge signing it and no hearing, or there's a hearing, but you're successful at it, the judge will sign the order for expungement, and then that gets sent around to everyone who possibly could have any record of this charge, the arrest, whatever it is. And all of those places have 60 days to expunge the record. Again, right now with the pandemic and closures, it might take a little longer than that, but it depends. They're usually pretty good about it. So the police department. So I like to say that if you get an expungement and it's ordered off your record, you're going to get and if we represented you, I get it too, but you get an order in the mail, and then you start getting these things called certificates of compliance. So you'll be getting mail from the police department saying, we complied with this order for expungement, and we've destroyed this record. So I like to put that out there, because if you do file for expungement, it can be a little scary if you start getting mail from the police department or some other agency that you're not expecting something from. But this is probably one of the only times it's a good thing to get mail from the police department, that certificate of compliance. So that's how the process works. It can take a couple months typically, but some places are really backed up. Places like Baltimore City, if your charges are there, so you have to file in the court where the charge was. So if you had a Baltimore City District Court charge that you want to expunge, you file there. Sometimes they can take a little longer because they're getting a lot more of these. They're busier than the smaller counties, things like that. But in general, this is how it works. And then that's basically it for expungements. It's not too complicated, but it does get a little tricky. So I do want to put out here is our contact information at Legal Aid. This is for the Community Lawyering Initiative Division. So if you look, that phone number, 443-451-2805, or you can just email us at lawyer@mdlab.org and just email, I need an expungement, or it doesn't need to be expungement. So we do all those things I talked about. So if you have a family law issue, or you're having a housing problem right now, or you can't get your benefits or something like that, just email over to us and someone will reach out to you pretty quickly and do that intake I talked about in the beginning, and then match you up with one of our attorneys. You can also always feel free to email me at mshooting@mdlab.org. That's my personal email. Totally happy to get emails from anybody and get you the assistance you need. But that being said, my last name's a lot trickier to spell than lawyer. So either one works really well. So if you need anything, please let me know. Any questions, I'm happy to answer them. If you do have questions about your personal record, I would ask to just call us instead, because we want to keep that confidentiality and not put all that information out there. But anything you need, please feel free to ask now or reach out at any time. We're always here. Thank you.